Well, thanks everyone for coming. Good afternoon. Welcome to our, I think, third annual U.S. Supreme Court preview panel for the October 2024 term. It's wonderful to see so many of you here today. My name is Alan Rozenshtein. I'm an associate professor of law here at the University of Minnesota. But much more importantly, today I am joined by a distinguished panel. First, we have Judge Elizabeth Bentley, formerly a faculty member here at the law school and the creator of this preview panel event. So thank you for coming up with this a few years ago. Judge Bentley is now serving in the Minnesota Court of Appeals. Professor Kristen Hickman is the distinguished McKnight University professor and an associate dean, or the associate dean here for academic affairs. And then we have Professor Nadia Anguiano, who directs our federal immigration litigation clinic. We are very fortunate to have such a talented group of scholars and practitioners with us here today, each bringing their own unique expertise and perspectives on the issues before the court this term. We'll be offering our thoughts on some of the major cases and themes of this upcoming term. This year's Supreme Court term may not be as packed, at least not yet, with landmark rulings as the past couple of years have been, terms that brought us high-profile decisions on affirmative action, presidential immunity, disqualification from the presidency under Section 3 of the 14th Amendment, and the overturning of Chevron. But this upcoming term is still shaping up to be a significant one. And the court's decisions will have profound implications for a variety of important legal and social issues, and we're eager to share our insights with you. In addition, whatever the Supreme Court rules this term, it is likely to remain at the forefront of public attention due to persistent questions about its conduct and legitimacy. Public confidence in the court continues to hover at historic lows, a trend exacerbated by ongoing scrutiny of individual justices' ethical practices. The controversy, for example, surrounding Justice Thomas's undisclosed gifts from wealthy benefactors has reignited debates, for example, about the need for a more robust code of ethics for the nation's highest court. Furthermore, many in the Democratic Party, including Vice President Kamala Harris, have increasingly vocalized support for a range of controversial Supreme Court reform proposals. These include measures some critics characterize as court packing, such as expanding the number of seats on the bench. This political discourse, coupled with the court's recent contentious decisions, ensures that the institution will remain under intense public and media scrutiny. The court thus finds itself in the unusual position of being both a subject of and an arbiter in some of the nation's most divisive political debates, a dynamic that is likely to persist regardless of the specific cases it hears this term. But in any event, this term the court is set to hear cases on a diverse range of issues, including First Amendment challenges to state regulation of adult content, federal regulation of transgender healthcare, agency interpretation of statutes after Chevron, and a variety of important immigration issues. These cases, while again perhaps not grabbing the same headlines as some of the blockbusters of recent years, have the potential to reshape important aspects of American law. Each of us will address these and other cases the court is set to decide, after which we'll reserve time for question and answer. We encourage all of you to ask questions and engage in the discussion. Your perspectives and curiosity are an essential part of why we do these events, and so we look forward to hearing from you. I'll start with some important cases at the section of digital technology and the First Amendment. So I don't know, there we go, thank you. Before discussing Free Speech Coalition versus Paxton, I actually want to briefly mention a case that is likely headed to the court this year, although the court is not yet in a position to grant cert, so it's not on this PowerPoint. And that's litigation over federal legislation enacted earlier this year that would ban the popular social media platform TikTok unless its owner, the Chinese company ByteDance, defends its stake in it. The DC Circuit heard oral arguments in the case last month, and although the panel, at least based on my reading of how the argument went, is likely to uphold the law, the Supreme Court is almost certain to review whatever the DC Circuit concludes. So keep an eye out on that case, as it has wide-ranging implications, not just for tech regulation, but also for issues of national security and international business relations. Okay, so with that, let's now talk about the case I'm going to discuss, Free Speech Coalition versus Paxton. This case challenges the constitutionality of Texas House Bill 1181, a law that mandates age verification on websites that host a substantial amount of adult content, and requires them to display specific health warnings. The plaintiffs argue that the law violates the First Amendment by significantly burdening adults' access to constitutionally protected speech. The central question is whether Texas's requirement for websites to verify visitors' ages and display health warnings is an undue burden on free speech that should be subjected to strict scrutiny, as opposed to the lower rational basis review applied by the Fifth Circuit. So specifically, HB 1181, which was scheduled to take effect on September 1st, 2023, applies to commercial websites where over 1/3 of the content is considered, quote, sexual material harmful to minors. These websites must comply with two key requirements. They first must use age verification mechanisms, such as government-issued identification, to restrict access to minors. And they also must display prominent health warnings on their landing pages regarding the alleged risks of pornography, including claims about negative effects on brain development and social behaviors. The U.S. District Court for the Western District of Texas initially granted a preliminary injunction to block the law, finding that both the age verification requirement and the compelled health warnings likely violated the First Amendment rights of adults, rulings based on important Supreme Court cases, Ashcroft versus ACLU and Reno versus ACLU. On appeal, the Fifth Circuit applied rational basis review to the age verification requirement, reasoning that the law aimed to protect minors from accessing harmful content, similar to prior cases such as Ginsburg versus New York, a case from 1968. The Fifth Circuit importantly argued that Ashcroft and Reno were not binding because those cases addressed different technological contexts and relied on outdated assumptions about the feasibility and intrusiveness of age verification methods. The Fifth Circuit vacated the injunctions on the age verification requirement, but actually upheld it for the health warnings, finding the warnings to be an unconstitutional compulsion of speech. The Free Speech Coalition and other plaintiffs assert that the law is unconstitutional because it restricts adults' access to lawful content under the guise of protecting minors. And they argue that the Fifth Circuit's use of rational basis review contradicts established Supreme Court precedent, which requires strict scrutiny for content-based restrictions on free speech that impacts adults. Similarly, many commentators have criticized the Fifth Circuit for refusing to apply binding Supreme Court precedent, adopting instead a more lenient rational basis review. The petitioners also highlight that technological improvements in age verification methods do not eliminate the substantial burdens on free expression posed by the law. Overall, my prediction is that the Supreme Court will likely reverse the Fifth Circuit's decision and ultimately strike down the Texas law. This outcome would be driven not only by traditional First Amendment considerations, but also by a desire to send a clear message to the Fifth Circuit about the importance of adhering to binding Supreme Court precedent. As an aside, I think it's worth noting that nearly 25% of the cases the court is hearing this term, at least so far, originate from the Fifth Circuit. This is a stark contrast to when I was in law school, when it was the Ninth Circuit that frequently found itself overruled by the Supreme Court. The shift is, don't worry, the Ninth Circuit still gets that treatment often. This shift is particularly intriguing given that both the Fifth Circuit and the current Supreme Court are considered quite conservative, suggesting that the Fifth Circuit's rulings may be too extreme even for the 6-3 conservative supermajority on the High Court. Nevertheless, the broader implications of the court's decisions will largely depend on how narrowly or broadly it chooses to rule. A broad ruling could effectively preclude most age verification laws from satisfying First Amendment scrutiny. And not just that, but could cast into doubt a lot of the child safety laws regarding, for example, social media that are currently going through many of the states. On the other hand, a narrower decision might leave room for further experimentation with child safety legislation at both the federal and state levels. The scope of the court's ruling will thus be crucial in determining the future landscape of online content regulation and child protection measures. More broadly, this case marks the latest in a series of online speech cases the Supreme Court has recently considered, following on the heels of Gonzalez versus Google, which attempted, albeit unsuccessfully, to address the meaning of Section 230 of the Communications Decency Act, and last term's Net Choice versus Paxton concerning state regulation of platform content moderation. The court's increased attention to these issues demonstrates a growing recognition of the importance of free expression online after what could, at best, be considered decades of benign neglect. As the digital landscape continues to evolve rapidly, the court seems increasingly willing to grapple with the complex intersection of free expression and internet regulation. And this trend suggests that the court is now actively seeking to establish clearer guidelines for free speech in the digital age, potentially reshaping the legal framework that governs online expression and content. So with that, I will turn it over to Judge Bentley.
Great. Thank you, Professor Rozenshtein. Hi, everybody. It is so wonderful to be back. It's just great to see so many former colleagues and former students here in the audience. I absolutely love this law school, and so it's a thrill for me to have a chance to get back and talk to you today. So in my new role as a judge, I think it's just important to point out that that I'm not going to be able to give my personal views on these cases or how I think that they should be decided. Rather, my role here is to come and kind of give you information, kind of a preview about what the cases are about so you can follow the arguments and decisions when they come down and kind of present the both sides, but just want to make sure that everybody knows that during the Q&A time I won't be able to answer questions about my own personal views about how I think these different issues should be decided.
They don't let you have any fun, do they?
No fun. Only behind closed doors. Okay, so the first case that I am covering, I have two today. The first is United States versus Skermeti. So this is a case that the court's going to hear relating to a challenge to the Tennessee law that prohibits gender-affirming medical care for transgender youth. In March 2023, the Tennessee state legislature passed a law that bans hormone treatments like puberty blockers or other hormone therapy treatments for trans youth, and these, again, this is only applies to minors. It also bans gender transition surgeries, but I want to note that only the hormone therapy treatments are included in the question presented to the Supreme Court. So the challenge to the surgery is not currently before the court, so you won't see them deciding anything related to that. And that part of the law has been kind of put on hold or struck down and will not be in effect regardless of what the Supreme Court decides in this case. So looking only at the hormone treatment aspect of the law, it specifically bans such treatments if they're prescribed for the purpose, quote, of enabling a minor to identify with or live as a purported identity inconsistent with the minor's sex, or, quote, treating purported discomfort or distress from a discordance between a minor's sex and asserted identity. So that's the statutory language. It's important to note that the law does not apply to other youth who are receiving treatments for other conditions. So for example, it allows hormone therapy treatments for youth who may have begun puberty too early, or youth who were intersex and didn't have a clear sex assigned at birth. As an enforcement mechanism, the law subjects physicians to possible civil penalties. They may lose their medical license or even be subject to private civil lawsuits. So this case was brought by 3 transgender youth who had begun treatments after extensive consideration with their families, healthcare providers, and/or psychotherapists. The plaintiffs also include the parents of the youth and a doctor who provides care to trans youth in Tennessee. They challenged the law as a violation of both the Equal Protection Clause of the Constitution as a discrimination on the basis of sex, and as violating the concepts of substantive due process. So again here, the court is not, this is another piece where they're carving something out. The due process claims are not at issue in the case. They weren't part of the question presented to the court. So the court's only deciding it on equal protection grounds. The procedure is kind of fun here for those civil procedure, those of you taking it this year. The United States intervened in this case in support of the youth. So they were an intervening party, and so those are against the state. So those are kind of the players. The district court initially ruled that the laws relating to hormone therapy violate the Equal Protection Clause and struck down the law. But the Sixth Circuit reversed and reinstated the law. And a majority of that court held that the laws actually don't discriminate on the basis of sex for purposes of the Equal Protection Clause, and for that reason, they're not subject to a heightened scrutiny. So you heard a little bit in Professor Rosenstein's summary about the First Amendment, and there are different levels of scrutiny we apply to First Amendment challenges. The same thing in equal protection challenges for those of you who haven't taken a 14th Amendment class yet, which I'll just put a plug in, you all should before you leave this law school. But there are 3 levels of scrutiny that typically apply to equal protection claims. There's strict scrutiny, which is the highest level of scrutiny for government laws or action that differentiate among people on the basis of certain fundamental characteristics like race. Then there's intermediate scrutiny, which is less than that really strict scrutiny, but higher than the lowest bucket, which I'll get to in a second. And the intermediate scrutiny is typically what applies to sex-based discrimination. And the lowest bucket is rational basis, which applies to most other kinds of differentiation among similarly situated people that aren't in one of those heightened classes. So the important piece here is the Sixth Circuit held, because it's not sex-based discrimination, it doesn't fall into that intermediate, you don't get any level of heightened scrutiny. And it held that laws that treat transgender individuals differently from similarly situated cisgender people warrant only that really deferential rational basis review. right? So applying rational basis review, the Sixth Circuit says that these laws satisfy rational basis, and the majority focused on what it perceived as being the potential long-term consequences of gender-affirming care, and concluded that the political and legislative branches should be the ones to handle and weigh the risks and benefits of those, and not the judicial branch. So, kind of the big theme was this should be left to accountable elected officials. So after that decision in the Sixth Circuit, remember I said the United States came in as an intervener. The United States filed a petition for certiorari to the Supreme Court, and that is the one that the court granted. So the United States here is the petitioner. If you look at the docket, you're thinking, where are the youth in this, right? The United States is the petitioner. The youth are still in the case. They're called respondents, but they're actually respondents supporting the petitioner, the United States. And then the state officials are also other respondents, right? So usually in the court, when you grant a case, the petitioner is just the one whose petition gets filed. Every other party, regardless of what side you're on, you're called a respondent, and then you kind of filter out where you file your brief and kind of the timing. So that's getting way into the weeds, but and again, the court only granted the equal protection claim. So the big issues here that the court's going to decide are, first, is this discrimination on the basis of sex? So what level of scrutiny are we going to apply? You might, this might remind you of a case from a handful of years ago you may have saw in the news, or for those of you who are in, I don't know if anybody would have been in law school this time, but called Bostock, which was a case where the court held that Title VII's prohibition on discrimination on the basis of sex includes discrimination on the basis of sexual orientation. And so this case kind of reminds of those questions, is what is discrimination on the basis of sex? What's different here is that that was a statutory interpretation case about what Title VII means, what Congress wrote. The reasoning doesn't apply directly to the Equal Protection Clause. So we can't say that, that just because the court kind of made that decision as a statutory matter that they would apply similar reasoning here. At the same time, I think you'll see a lot of similar kinds of arguments in this case, that in fact this is discrimination on the basis of sex, even if it's not maybe what was exactly contemplated at the time that the text of the Equal Protection Clause was written. The United States says that it is discrimination on the basis of sex because it applies only to youth who do not identify with the sex they were assigned at birth. It doesn't apply to other youth who are seeking treatment for other reasons not associated with their gender identity. So that's kind of the way that the United States is putting it. Tennessee, on the other hand, is responding that the distinctions aren't on the basis of sex. It's really just about what your age is and what medical treatment you're trying to receive. And in determining what medical conditions or restrictions on medical conditions apply, the court should defer to the state legislature to weigh the benefits and risks. So this aligns with what the Sixth Circuit was holding before, that these are kind of medical decisions that we should leave to state legislators. And so there's not a differentiation based on sex. It's just about whether you fit into the care that's been determined appropriate. Of course, there are a handful of amicus briefs written by medical associations supporting the youth that say that these treatments are safe and effective. And so to leave, the response argument is to leave it to the state legislatures when there's medical support for the treatment. It may not be a rational way to, or a reasonable way to interpret the effect of the law. So I also think one thing that we might see pop up, so when you're thinking about equal protection claim, this came up in the Dobbs decision in a very small paragraph at the end of the decision that talked about whether the Equal Protection Clause created any kind of right to an abortion. And there was a little bit of language there talking also about kind of the Equal Protection Clause in the abortion context. And there, Justice Alito wrote in the majority that the regulation of a medical procedure that only one sex can undergo does not trigger heightened scrutiny unless the regulation is a mere pretext designed to effect an invidious discrimination of members of one sex over the other. So you see, at least in there, the court's talking a little bit about how to reach the level of sex discrimination or what constitutes sex discrimination for purposes of heightened scrutiny. This is different because a procedure, hormone therapy treatment for a transgender youth doesn't necessarily apply to one, quote unquote one sex or the other in the same way that a reproductive medical procedure would, but I still wonder if we may see some of that language come up to play as far as what you need to show to reach that level. The court has not scheduled oral arguments yet, and so you'll have to keep your eyes open for that, but it'll certainly be an interesting one to follow when it does. All right, so shifting gears to the next case is just kind of a totally different issue. It's called Garland versus Vanderstock, and it's about the ghost guns and whether or not the ATF can regulate ghost guns under the current statutory framework. So in order to understand this case, you have to go back to 1968, where Congress passed the Gun Control Act, which imposes certain licensing, background check, record keeping, and serialization requirements on persons who are engaged in the business of importing, manufacturing, dealing in firearms. Right? So under that act, it defines a firearm as any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such, now I'm like losing my place in here. Okay, it includes either the weapon, which is designed or may readily be converted to expel an explosive, and the frame or receiver of that weapon. Okay, I was getting ahead of myself. All right, so the question is whether the ATF, which wrote a new regulation in 2022, which was trying to get at this huge increase in the number of what's called ghost guns on the market. And basically, ghost guns are untraceable firearms. They're made without serial numbers. They may be made from kits and parts that are largely available online, and somebody with just basic tools and skills can assemble eventually a fully functional firearm. So in order to reach those products, to say that they are regulated under the Gun Control Act, the ATF wrote a regulation clarifying that that term firearm that I identified before includes a weapons part kit that may readily be converted to expel a projectile, or one that may be readily converted to function as a frame or receiver. Okay, so it's basically trying to fit these weapons kits into the definition of a firearm. It's important to understand that the regulation doesn't prohibit weapons parts kits. It just says that if you sell or trade in any of these, you're subject to the same kind of regulation that you would be if you were selling a firearm. So you have to put serial numbers on them. You may have to do background checks of people before you sell them to somebody, or you kind of the same thing as if it was a firearm. And it turns out that that's a pretty big deal for this industry. So as soon as this law went into effect and initially was struck down, it's been, I'm not going to go into the back procedural history, but the law has been held, while this case is going on, it is in effect, the regulation is in effect, and it's basically tanked the industry of weapons parts kits, because it turns out people really only wanted to buy these if they didn't need to have a serial number, all right? As soon as you're like, oh, you need a background check, nobody wants to buy them. And that came up a little bit, I'll tell you, in the oral argument this morning. So anyway, the case is going to come down to a lot of different questions on statutory interpretation. What is a weapon, right? Does a weapon include a weapons part kit? What does it mean to be readily converted? Like, how quickly do you have to do it? How much time does it take? The government maintains it can be done in as little as 15 to 20 minutes. What does it mean to convert something into a weapon versus building it for the first time? Is that the same kind of thing? Interestingly enough, I alluded to before, the court heard oral argument on this morning, which was really fun for me. So I was like, oh, good, it's perfect timing. I can give you guys some real-time insight. The Solicitor General, Elizabeth Prelogger, said during oral argument that she had the chance to put together a firearm from one of the weapons kits, and it turns out she can do it. I don't know what that means. I guess I shouldn't judge her skills in weapon craft, aside from this, but it at least makes you think, well, if she can do it, maybe I could do it. Maybe anybody could do it, right? So this case comes on the tails of a decision last term, which was called Garland versus Cargill. You may have heard about it last spring or last summer. It's the bump stock case, which is the question of whether the term machine gun in the statute included a bump stock firearm, which is an accessory that allows a semi-automatic rifle allows the shooter to like rapidly re-engage the trigger on a semi-automatic rifle, and whether or not is a machine gun. The court in that case said no, it was not. The bump stocks are not machine guns. So the question here, it'll be interesting to see, do they stick to that like really narrow construction of statutes that isn't kind of going to allow for accommodating these interpretations or new technologies that are kind of making products that are more easily converted to the definitions that Congress wrote in the statute. But after listening to the oral argument this morning, I actually think that it looks like this one's probably good to go. That the court didn't seem to be really concerned about this regulation. Justice Alito was the person who gave the Solicitor General the hardest time on it. And his question, I thought he had a couple of good questions, which were, he had a pen and a notebook and said, if I have this pen and notebook here, does that mean that I have a grocery list? And you're like, well, I guess these are the parts of a grocery list, but no, the Solicitor General said, no, these are not the same thing because they can also be readily used for anything else. It's not like something that is obviously going to turn into a grocery list, right? It could be anything. And he said, well, what about, eggs on a table and butter and cheese and some salt? Is that an omelet? And she said, no, you could still use those for anything else. And then I like Justice Barrett pops in and says, well, what if you had ordered an omelet kit from HelloFresh and it had all the ingredients and the things? And the Solicitor General said, yes, then that's an omelet, right? So there's a difference if you get the kit with all the things and it's boxed up and it's like has everything you need for it, then that would be an omelet. Okay. And going back to the point about the hobbyists, so a big piece of this is really just for people who are in the like putting together guns, and it's not meant to get around these rules or be used for criminal activity, and that in general to use something for a hobby shouldn't be prohibited or isn't what the ATF or the Gun Control Act was trying to get at. And the Chief Justice, I thought, seemed quite skeptical that the people purchasing these are in fact hobbyists. In fact, if it takes 15 or 20 minutes to do it and all you have to do to build it is drill a couple of holes, that doesn't sound like something a hobbyist is really, the hobbyist wants to build it from scratch. And I think that especially with the market that you've seen, that in fact that doesn't seem to be the folks that are purchasing these, or they might as well just get their background checked. So I think it's likely that the regulation be upheld, but then again, you can never predict what the court's going to do, so I won't hold my breath. But anyway, it'll be interesting to see when that one comes out, probably sometime over the winter.
I will say I love the anecdote about Justice Barrett and HelloFresh. It's like judges, they're just like the rest of us.
So true.
Okay, so I'm here to talk about administrative law, which is very hot at the Supreme Court right now. Has been for the past few terms. I see no sign of that changing in this term. To provide just a little bit of sort of 64,000-foot meta context for these cases, let me say a few things about broader trends in the Supreme Court's administrative law jurisprudence. Today's Supreme Court, it will come to no surprise, I don't think, to any of you, is more originalist, more textualist, more structurally formalist, and more skeptical of actions taken by independent and executive branch agencies than it has been for about 100 years. That said, so in the 1980s and 1990s, the Supreme Court was all about judicial restraint in the administrative law context. The justices interpreted the Constitution, the Administrative Procedure Act, and their own precedents in ways that gave the executive branch a lot of latitude when it came to policy making and statutory interpretation. The justices did this by giving judicial deference to agency interpretations of statutes and regulations and agency policy making, and they also did this by limiting access to judicial review in the first place through their interpretation and application of doctrines like standing and finality and their reading of statutes that cut off judicial review. These moves were themselves a reaction to an earlier time in the 60s and 70s when the courts were more intrusive about second-guessing agency action. And these moves were always controversial. Even 30 years ago, legal scholars were expressing concern that courts were emboldening the executive branch too much by cutting off judicial review and deferring to agency action. The parties, to some extent, may have flipped ideologically, but it wasn't universal either way. It was sort of across the board. And arguably, for a variety of reasons, including the Supreme Court's standoffishness, but also congressional paralysis, agencies became, over time, more aggressive, arguably, in their actions. Now, if you watch the Supreme Court over time, it's often easy to see a pendulum effect in the court's decisions as it reacts to one set of decisions, arguably overreacts, and then switches back the other direction. For at least 15 years now, in the administrative law space, the Supreme Court has been slowly but surely broadening access to judicial review and scrutinizing executive branch actions more closely. The two cases I want to talk about now potentially continue that trend. Certainly that has been the trend the last few terms. First, let's talk about Food and Drug Administration versus wages and White Lion investments. So, if you want to introduce a new tobacco product into interstate commerce, under statutory law, you have to get permission from the Food and Drug Administration to do that. For several years now, the FDA has systematically been issuing orders rejecting applications for market authorization for flavored e-cigarettes or vaping products. The federal courts of appeals have divided sharply over whether the FDA's denial of these applications has been arbitrary and capricious under the Administrative Procedure Act, and a doctrine known colloquially by the term, the case in which the Supreme Court embraced it, State Farm. Now, the Administrative Procedure Act calls upon courts to set aside agency actions found to be arbitrary, capricious, and abuse of discretion or contrary to law. The State Farm doctrine has interpreted that statutory language as requiring agencies to explain and justify their actions at the time that they take them, or in other words, to contemporaneously demonstrate reasoned decision-making. The Supreme Court adopted the State Farm standard in 1983, and then didn't do a whole lot with it for a few decades, although the courts of appeals certainly did. The State Farm standard is supposed to be fairly deferential in giving agencies a fair amount of latitude in making policy choices, with judges just making sure that agencies acted within statutory boundaries, had good reasons for their actions, took into account all the things that Congress wanted them to consider, didn't take into account things Congress didn't want them to consider, and so on. But State Farm arbitrary and capricious review also looks askance at agencies that behave inconsistently, often interpreting inconsistency as evidence of arbitrariness, unless the agency, again, can offer good reasons for changing its mind. So in Wages and White Lion, the challenging parties claim that the FDA has been pursuing a blanket policy of preventing all non-tobacco flavored vaping products from reaching the market without saying explicitly that's what they're doing. The Fifth Circuit found that the FDA had in fact been inconsistent in its requirements for market approval. In a similar case, the DC Circuit declared that the FDA had pulled a surprise switcheroo regarding the studies it was going to require before granting market approval. And the Fifth Circuit agreed and said the FDA had behaved inconsistently without good reasons for the inconsistency. The Fifth Circuit also said that the FDA's explanation for its actions hadn't sufficiently addressed alternative approaches, as well as concerns that had been raised by regulated parties about its actions, both of which are expectations for reasoned decision-making. But again, Other courts, other circuit courts, have upheld the FDA's market authorization denials as reasonable. Now, State Farm challenges tend to be very case-specific. So it's difficult to predict with any degree of certainty any particular, generalizable rules that the Supreme Court will, articulate about the FDA's actions that we can apply in future cases. But State Farm cases are always interesting, making this one sort of one to watch for whatever it is that the Supreme Court does happen to say about how the FDA went about making its choices. Turning then to Nuclear Regulatory Commission versus Texas, this case asks whether the Nuclear Regulatory Commission has the statutory authority to license private entities to temporarily store spent nuclear fuel away from the nuclear reactor sites where the spent fuel was generated. The NRC claims the authority to issue the licenses. Texas claims that the NRC doesn't have that authority. The Fifth Circuit read the statutes and held that the statute's text, using traditional tools of statutory interpretation, clearly did not authorize the NRC to grant licenses to store spent nuclear fuel off-site. The Fifth Circuit then offered an alternative holding, saying that even if the statute wasn't so clear, deference to the NRC's interpretation of the statute was unwarranted because where to store spent nuclear fuel is an issue of substantial political and economic significance, and the Major Questions Doctrine requires Congress to be clearer about giving the NRC that kind of authority. Now, the Major Questions Doctrine is a canon of statutory interpretation that the Supreme Court has been applying much more robustly in recent terms. It originated from some cases and pronouncements in the 1980s and 1990s, but it used to be part of the court's Chevron jurisprudence and just sort of buried in there. The Supreme Court has pulled it out in more recent terms and applied it much more assertively than in the past. The briefing so I will say also, you may be aware, Professor Rozenshtein alluded to it, that last term in Loper-Bright Enterprises versus Raimondo, the Supreme Court overturned what was known then as Chevron deference, or the Chevron doctrine, which had counseled judicial deference to agency interpretations of statutes. The briefing in this case so far, it's all cert stage briefing, but it was all filed before the Loper-Bright decision. The briefing had a lot to say about the Major Questions Doctrine, but post-Loper-Bright, people are watching this case to see what the court might have to say about Loper-Bright, about the Major Questions Doctrine, and about the intersection of the two when it comes to agency statutory interpretation. Nobody's quite sure at the end of the day what the court's going to do with Loper-Bright. There's a lot of questions in Loper-Bright that remain unanswered. Meanwhile, there are lots of questions about Major Questions Doctrine and how it ought to be applied, and nobody's really sure how the two work together, if they do at all. Some people think the Major Questions Doctrine was rendered moot by Loper-Bright's decision to overturn Chevron deference. We'll just have to wait and see. But first, before the court can even get to those merits, it has to decide whether the Hobbs Act will actually allow it to consider the case. The Hobbs Act generally allows parties who are aggrieved by an agency's final order to petition a court of appeals directly for judicial review. The circuits are divided over whether parties who were not part of the original proceeding before the agency can seek judicial review in the Court of Appeals if the claim in question is that the agency exceeded its statutory authority. In other words, what is a party aggrieved under the Hobbs Act, as the Hobbs Act uses that term? Texas was not the party seeking a license from the NRC to store spent nuclear fuel off-site. It opposes that action. So is it a party aggrieved by the NRC's order for purposes of the Hobbs Act? Texas points to recent cases from the Supreme Court broadening the availability of judicial review of agency actions, including one from just last term in a case called Corner Post, which involved a different statutory limitation on judicial review that the court interpreted broadly or interpreted in a way to broaden access to judicial review. The court could avoid the merits in NRC versus Texas entirely, simply by concluding that the Hobbs Act doesn't authorize Texas to challenge the NRC's order before the Fifth Circuit. Nevertheless, personally, in my heart of hearts, I'm really hoping they get to the major questions and Lipperbright ideas. I think that's really interesting, but we'll see. And with that, let me turn it over to Professor Anguiano.
Thank you so much. As Professor Rozenshtein said, I think part of the awesomeness, for lack of a better word, of this event is to hear from you all. So I'll try to be a little speedy with the cases that I discussed to leave time for Q&A. I'm going to talk about two cases that are, one is an immigration law case directly, and the other is a criminal law case that does have some implications for immigration law as well. And before I get into the nitty-gritty of both of the cases, I'd also like to take a few minutes to talk a little bit more high level about how I see these cases, their potential impacts, and maybe what they represent about some of the trends in the Supreme Court of recent years. The first one, Velazquez, is what I would see as maybe a continuation of the Supreme Court's recent trend of taking what might seem as pretty technical procedural questions in immigration law that then really have a pretty outsized impacts on some of the populations that, for example, my clinic serves. I see in some ways this as another example of a case like the one that my clinic and Professor Bentley's clinic, then Professor Bentley, now Judge Bentley's clinic, teamed up last year to litigate at the Supreme Court that also involved a pretty technical procedural issue. And so in Velazquez, I think we'll see how the court treats some of these, again, fine procedural issues and how it views some of the bigger impacts that advocates are arguing the case has on non-citizen populations. And Delegati is a purely criminal case that I find actually really exciting. I don't think I'm going to get into the facts, but it involves, I think, like the mafia in New York. Read up on it. It's actually kind of fun. Not the behavior. The behavior was not fun, but to have a real law mafia case, I don't know, kind of piqued my interest. And in that case, the Supreme Court is going to interpret a very pesky statutory term called crime of violence. I wish I were a fly on the wall at the Supreme Court and could ask the justices how they view this term, because it seems to come up at the Supreme Court almost every other year, and I think they absolutely hate interpreting the term crime of violence. And that the court's decision in that case will again have broad impacts, not just in terms of sentencing, but also immigration and figuring out what kind of offenses render non-citizens removable. So I'll start with Velazquez, and I'm going to talk high level about some background in that case. When a non-citizen is placed in removal proceedings, meaning the United States government is seeking to remove them, if they lose in immigration court, they will end up with an order of removal. One of, I guess, maybe the ameliorating or a sort of harm reductionist statute within the Immigration and Nationality Act allows an immigration judge to grant something called voluntary departure instead of entering an order of removal. And the reason that's beneficial to a non-citizen is that if they voluntarily depart, pay their way out of the country, they can avoid some of the more negative consequences of having an order of removal. That's, for example, being barred from certain eligibility for relief, and also being barred from not entering the country for 10 years. But if they don't voluntarily depart, then those consequences attach, and also they are subject to a fine in the order of about $3,000. When the immigration judge grants voluntary departure, the non-citizen has 60 days to voluntarily depart from the United States. The question that the court is going to consider, and if they don't depart, then those consequences attach. So then the voluntary departure order then basically becomes an order of removal. The question that the court is going to answer is if when the voluntary departure period ends, if it ends on a holiday or a legal holiday or a weekend, whether the non-citizen has until the next business day to actually file something in immigration court that would stop that voluntary departure period. And so civil procedure, how do you count days? Basically, if the deadline falls on a weekend or a legal holiday, do you have until the next business day to basically take action? And so unsurprisingly, the non-citizens are arguing that yes, you have until the next business day, and the government is saying absolutely not. You basically have until the day, to the 24 hours in calendar days when the voluntary departure period ends. And so the consequences here are, again, pretty significant for non-citizens, depending on which way the court rules. The majority of non-citizens are pro se in immigration court, lack sophistication, lack language skills, and the advocates are arguing or trying to bring some of those issues to the fore. Something kind of nerdy that I think is really interesting in this case is the way that it's being argued is actually that a common law presumption applies to the Immigration Nationality Act, and that common law presumption basically says we don't do anything on weekends. Like there's, basically like if things fall on a weekend, we don't do anything. And that's why we do it the next business day. And that, I think the way that the court interprets whether or not a common law presumption can be applied to the INA has the potential to also affect a bunch of litigation that, for example, our clinic has done when we've argued that other common law presumption like res judicata or laches applied to the INA. So in deciding this question, I think the court could potentially elucidate some advocacy angles. And I think the court's gonna say that we have until the next business day, but we'll see. I'll talk about delegati now. And that one, really complicated case, but it comes down to the court's interpretation of the crime of violence definition in criminal law. And a crime of violence is an offense that has the element, the use, attempted use, or threatened use of physical force against the person or property or another, or property of another. And to make a long story short, if you're convicted of a crime of violence, that basically heightens your sentence, makes it a minimum consecutive sentence of 5 years up to life. And in immigration law, that definition is cross-referenced, and some offenses that are considered or are held to be crime of violence offenses make you removable and bar you from discretionary forms of relief. And so what the court is going to consider is essentially whether crimes of omission constitute crimes of violence because they have as an element the use, attempted use, or threatened use of physical force against the person. As one of a dissenting judge in the split phrased it, is basically the court is going to decide whether, for example, a crime such as a caretaker failing to or ceasing to feed an elderly parent who has a terminal illness, and as an act of mercy even, would constitute a crime of violence because it results in bodily injury and ultimately somebody's death. Unsurprisingly, Mr. Delegati says no, that by its nature and just reading the statutory definition, a crime that has the element, the use, attempted use, or threatened use of physical force against a person necessarily involves a volitional act of using violent force against that person. And as I mentioned, some of the broader impacts there are that it's a really significant provision in sentencing, also in criminal law or in immigration law, But I think more than that, to piggyback off of Professor Hickman's point, I think that this decision is significant because it'll continue to tell us a lot about how the court is just conducting statutory analysis, right? And whether, to take a step back, the Solicitor General is arguing crimes of omission, of course, are crimes of violence because you end up killing someone, right? But if you take a more of a textualist view of the statute, I think personally the arguments are a little bit more compelling on the other side. I'm gonna end there, but I'll just name that for crime law nerds, I think this case also stands to say, potentially preview whether or not the Supreme Court may do away with something called the categorical approach, which is how people in my field and in criminal law will analyze whether or not a particular offense fits a statutory definition for crime of violence and other removal grounds.
All right, so I think we have a couple of minutes for some questions from the audience. So we have mics around the room. If folks want to raise their hands, we will get a mic to you so you can ask your question. Or the dean will cold call you. That's the other option. I saw a hand somewhere. Excellent, thank you.
Hi. There's been a lot of talk recently, and you mentioned it yourself at the beginning of this panel, about the public opinion regarding the court and the big cases that it's hearing. I'm curious to hear how you all define the big cases that the court hears, and if you've seen a change in the way that the court has approached those types of cases in your time of watching the court.
Okay, so I'm the old person on this panel, so maybe, you know, I'll go ahead and
We
take
prefer
that
the
one.
term senior colleague.
Thank you. Thanks.
Is that worse?
I was trying to be helpful.
Yeah, you wait till those AARP envelopes start coming through your mailbox.
Oh, I'm a member. I get discounts. Word to the wise to all you 25-year-olds. You can sign up for AARP at any age and you get wonderful discounts. Anyway, back to you, Professor Hickman.
Yeah, you know, so it's always surprising. I don't have a good answer. It's really surprising to me in some ways. You know, some cases are obvious. You know, I think First Amendment cases, cases that are part of the culture wars that have been going on, you know, these are the kinds of things that capture people's imaginations. But, you know, sleepy cases about things like, you know, fishing boat inspectors and, you know, spent nuclear fuel and things like that, you know, historically in my experience, you know, didn't captured that much attention, and now, like I say, administrative law is hot. Now, I've always thought administrative law was hot. You know, I mean, for 25 years now, I've been an administrative law nerd and get all excited about these cases, you know, because to me, this is really the nitty-gritty of government. And how can you get more exciting than the allocation of governmental power? You know, but then again, at the same time, you know, it has... Dave, you know, the idea of statutory interpretation I've always enjoyed, but it's only been in recent terms that I think these kinds of cases, how should we interpret statutes, suddenly has become, you know, and the allocation of governmental power aspect of that have suddenly become sort of front page New York Times kind of stuff. And, you know, I think that's probably just a reflection of our very polarized political times combined with the shift in personnel on the Supreme Court. But that's the best I've got.
I have just a super quick question for Judge Bentley back up here. Sorry if I missed it when you were talking, but when you were talking about United States v. Scrimetti, do you have a prediction in which way you feel the court might rule? Not your own personal opinion, of course, but just what you might see them doing.
No, I don't. And part of the reason is that the case is pretty early in the stages. So the United States and the youth respondents have filed their briefs, but the state of Tennessee hasn't even filed its brief yet. it has, and it hasn't been argued. So what I was reading was from their cert petition stuff, and I think a lot of the development still is a lot to come in the argument. So I don't have a great sense of it. And I guess I'll leave it at that. I think it's just too hard to predict at this point exactly where they're going. I mean, it's interesting that they granted it. They're obviously looking, but and sometimes you can't read a lot into the fact that the lower court struck down the laws. Like, just because they granted it doesn't mean that they disagree with that decision. And the other piece of it is that, you only need 4 votes out of the 9 justices to hear a case. So we don't know which 4 justices voted to hear it and why. And you have the Solicitor of the United States seeking the petition, so they brought it to the court. So again, it's just, I think at this point, just too many unknowns to know exactly how they'll come out on it. But at least those are the factors that, play out. And I think it'll become much more apparent during the oral argument. Like, if you were to listen to it, see what kinds of questions the justices are asking. And it doesn't always mean, sometimes you'll see a justice who might agree with a party, asking really hard questions of that party because they're trying to preempt the other one. So you can't necessarily just listen to a question and say, oh, they were giving them a hard time. But I think that, you get a feel for it once the argument's over as to kind of where the justices are sitting.
I think we have time for one more question.
Thanks. I think this will mostly be a question for Professor Hickman and Anguiano. Obviously, this court's skepticism towards agencies, I think, seems to have a different implication in the immigration context. So, how do you think about jurisprudence, if there are inconsistencies, if you agree with that, and if maybe some of the thoughts on here's how we're interpreting the statute for some agencies aren't applying to all sorts of decisions?
Yeah, so when Loper Bright came down, I kept getting questions from the media about how pro-business the Supreme Court was and how pro-business that decision was. And I said, wait a minute, you could easily, just as easily call it pro-immigrant, because it involved the court basically denying judicial deference at the end of the day to the government in immigration cases, just as it was denying the government deference in a case involving regulating the fishing industry. In fact, I would say much of particularly Justice Gorsuch's skepticism and opposition to Chevron deference came from his experiences in seeing the Chevron doctrine play out in immigration cases in a way that struck him as being fundamentally unfair. So I don't necessarily think that the trend in what the court is doing is inconsistent between immigration cases and other cases, so much as the spin on what you put, how you think about what the court is doing, whether you think of it as pro-business or you think of it as pro-immigrant.
What I'll add to that is I'm a little bit more skeptical, and I think it's to be seen. My fear that, not fear, but I think the way that I see a lot of this playing out is through Skidmore deference, as in fact, the Ninth Circuit already came down with what I think a pretty wrong decision of deferring to the agency on Skidmore deference post Loper Bright. And so I do think that it remains to be seen what Loper Bright actually really even means once the circuit courts start applying it to agency interpretations.
Well, unfortunately, we're out of time, but thank you all for coming, and please join me in thanking our marvelous panel.